Hello, I'm Bill Staten, and welcome to this Navarre presentation. My partner and good friend here, Whit Wilkes, is our attorney on hand, and want to introduce him to everybody because he is a valuable resource that we would like for all of you to take full advantage of. So welcome.
Thanks, Bill. It's good to be
today.
here with
Yeah,
you.
yeah, good. We're going to. There are a lot of things that all of you need to be aware of when it comes to estate planning, and we don't have time today to take advantage of all of them. But Whit and I discussed four key points that we wanted to go over today. And before we get into those, I wanted just to start by telling one quick story. My firm, Staten Financial Advisors, joined Navarre about 6 years ago. And when we did, one of our largest clients had just had his will and estate plan redone, spent thousands of dollars redoing it. And I talked to him and I said, well, we've got an expert right here on staff. Why don't you let him review all your documents because it won't cost you anything? And I practically had to grab him by the neck to convince him to let Whit go over the documents. But anyway, Whit reviewed them and found a number of glaring errors, which were quickly redone and fit into North Carolina law. So that's how valuable Whit is and can be to you. So we would encourage you to take full advantage of it. So again, Whit,
Yeah.
welcome, and
Thanks.
glad to
Bill.
have
It's
you
good
with us today.
Good to be here with you.
So we've got those four key points, and we want to get into them.
Yeah, I'll back up just a little bit bigger picture just about me, just so everybody knows that who I've not worked with before. I've been doing this for 30 years, not quite as long as you have been picking dividend-paying stocks, but the same passion you have for dividend-paying stocks I have for working with folks on their estate planning and other planning needs. And just to remind everybody, I oversee the Navarre planning team, and
Yes.
that comprises both the preparation of cash flow plans and estate plan reviews. And we have a great team that works with me on our cash flow plans, but I'm primarily the one that works with our clients on estate plan reviews. So just wanted to set that scene for everybody. So,
And you can see Whit is a fun guy. So estate planning we often think of as being boring and unexciting, but Whit makes it as fun as it can be. And he's worked with Staten clients as far away as California, and
yeah.
every single one of our clients that's worked with Whit has been very, very pleased with the results.
Thank
and that's
you.
a compliment to you.
Appreciate doing that. Yeah, so just to set the scene again, Bill, just for the folks that haven't worked with us before, our estate planning review process is a process, and it's part of a relationship. Getting your estate planning documents done is a transaction.
Mm-hmm.
You're going to pay a lawyer to do that, and then those documents are going to probably sit on a shelf somewhere. Whereas for us, it is more of the ongoing relationship with our clients that I think distinguishes what we do and what we don't do. We don't prepare documents. We look at them. We will make recommendations. We'll make referrals to either a new attorney if the folks need them, or if they have an existing relationship, we'll provide a memo, summarize our discussions with them, and that should theoretically make their time with their lawyer more efficient. But wanted to be clear, we are not a law firm. We don't practice law, but we work with our clients on that process. So I wanted to set the scene.
Yeah.
I think the first thing that we see in terms of mistakes is not having a plan at all.
Okay.
As I tell folks, and you've heard from me, you have a plan whether you want it or not. We have things in each state called intestate succession laws. And if folks have not gone and worked with a lawyer and then unfortunately pass away prematurely, there are laws that each state has as a backstop, and that's called intestate succession. You don't want that, as I tell people jokingly or not. Generally, it sets up a scheme that most people would find reasonable in terms of property going between a spouse or children or grandchildren. But I think you like to tell stories. We one of our other partners here, as you know, had a family member that passed away literally with estate planning documents on his desk, but they weren't executed. So one of our partners, until this minor child is 18, has to go to one of the clerk of court's office and actually do an accounting to the clerk of court to report the assets that are held for this minor. And so just an example of the pitfalls, the cost of not having a plan can go on and on for up to 18 years if you have a minor child. So that not having a plan is the first mistake that our families can work around.
And if you move to another state, you ought to have your documents
Very
reviewed
good
by a
point.
competent attorney,
Very,
right?
very good point. And I guess that's kind of the second mistake that we see is not updating a plan. A good point. As I have said before, life happens. What that means is people move from out of state, particularly in this more transient society that we have now. It's not, you don't grow up in Charlotte and live here 80 years. People are moving from city to city for their careers, state to state. And while most planning is done with an eye toward federal estate tax laws, certainly there are state by state requirements that we certainly, and I'm glad you brought that up, if folks are moving to North Carolina or South Carolina from out of state, you certainly want to get local counsel involved to look at those documents. But to your point, the updating of the plan is important as well. Documents kind of have a shelf life, and as I said, life happens. New family members come along, other family members pass along, and so part of the estate plan review process for us is making sure those documents are looked at. Again, for us, it's a relationship, not a transaction. When we go over documents with our clients as part of the review process, we look at both the substance of the plan, in other words, who is going to inherit certain property, is it going to be outright, is it going to be in trust, but most importantly, what we often uncover as part of our estate planning review process, Bill, is the fiduciary appointments, and that's the legalese that means who am I going to appoint to these various roles? Who am I going to trust to carry out my wishes as my executor under my will and as my trustee if a revocable trust is a component of that plan? We often see, as people get older, we look in and bring up these relationships with folks and say, who is this person that you've named? And they say, oh, that's my sister or my brother. And then we have to point out that, if they're the same generation as our client, that may not be the best because something could happen to that person that they've appointed as their executor and trustee. So that's, again, part of the estate plan review process for us to say, hey, let's look at those documents periodically and just make sure they're up to date both with the latest laws,
And the health is still
the
good of that
substance,
person.
and the person. Exactly. You hit the nail on the head. And that's something that we often, as you said with your story with that client, we kind of have an aha moment of like, oh my gosh, I didn't even think about that, Whit. So thank you for bringing that up, that we need to now name maybe our children. We work with multi-generations of families, as you know, and so that's one of the things that we often point out to folks that, gosh, you did your documents when your children were teenagers or young adults, but now they have families of their own, and they could probably fulfill some of these roles that we see that need to be appointed, whether it's executor or trustee for themselves. So great point there about that second mistake being just not updating your documents regularly enough.
Whit and I both know examples, this is a horrible example, but where the man had his will and estate plan all up to date for his first wife, but then he got divorced and remarried, but didn't change the documents, and he passed away, and all of his estate, pretty much all of it, went to the ex-wife.
Yeah, those are the kind of cases
Not the thing you want to happen.
you learn about in law school, Bill, and you hear about it at estate planning seminars that I go to regularly, and those are just the difficult ones. And
I know two people it happened to.
Those are the ones you don't want to be the lawyer and have to explain to the children or whomever that your father or your mother didn't update their plan and it's going to somebody else. And so that's, again, it's the concept of an estate plan being an evolving type of thing, and it's not just a transaction and put it in your lockbox and forget about it.
And then you have point number 3, thinking the will and or trust cover all your assets.
That's a great one, Bill. And by that, without getting too much in the weeds with our clients, your will and your revocable trust, as you've heard me describe before, those only cover your probate assets. And those are the assets that you own individually that don't have a beneficiary designation associated with them. Contrast that to an asset that we manage for our clients, like an IRA or a life insurance policy, which is a non-probate asset, which has a beneficiary designation, or through contract with a asset custodian or a contract with a life insurance company. We often encounter the situation you're talking about where folks, okay, check the box, we've got our will and trust done, and they think, because they're not a legal nerd like I am, that covers the waterfront. Well, they don't realize that just because you've done that, you need to make sure your 401k beneficiary designation is up to date. we have folks starting jobs and they're just probably, filling out paperwork and they're putting somebody in there as their beneficiary and they don't think about it for 20 or 30 years. And
Yes.
gosh, oh my gosh, that's not who I want to inherit that. And they think just because they've done their will and their trust, that covers everything. And so that's a huge mistake that we see when we're doing these estate plan reviews for our clients, that we say, okay, we want to see all your assets, even the ones we don't manage, and just confirm those beneficiary designations for our clients to make sure that doesn't slip through
All
the
the
cracks.
beneficiaries did.
Exactly. Even
You
better
haven't- and
point
you
there.
haven't
They're like,
changed
oh my gosh, I named my brother, or I had named my mom or my dad or something like that. Great point. And now those people are passed away, and then you get into this again an unfortunate situation of rules dictating where property is going to flow through may not be what the person wants. So that's a great point as far as the third mistake that we see a lot.
And not that this is all of them. Again, Whit's got a list of 10 really good points.
And I think, Bill, we're going to put a link in there for our
Yeah, we are.
clients to
Yeah.
see to this Wall Street Journal article that will, summarize some of these things we're talking about today.
But the point number 4, failure to execute planning documents regarding issues besides death.
That's a great one, Bill. What we're talking about there, and so far we've talked about the passing of assets at somebody's death, and that's what we hear about from estate planning. But most of our clients, when they're getting new documents done or when we're doing an estate plan review for them, we point out that that's only part of the estate planning equation. The rest is a healthcare power of attorney and a financial power of attorney. And these are very important documents that our clients need, that if they're incapacitated and can't make decisions for themselves for a healthcare perspective or for a financial perspective. And you say, well, gosh, I'm sure my wife or my husband or my kid could make these decisions for me. They could, but if you don't have these wishes articulated in writing ahead of time, you have to go to a court and get in front of a judge and have an emergency, hearing where somebody gets appointed. So it's so much easier to have this done ahead of time. And these are documents that our attorney friends out there are going to prepare for our clients as part of a package, just to say, gosh, if something happens to Bill, Mary's going to be able to make decisions for him, or if something happens to Whit, there's going to be children or whomever. Again, and you just assume that these things are in place, and I know our clients like to hear stories. We often, in our newsletter, as you know, every June, we put in there the little reminder for our families whose kids are graduating from high school and are probably 18 and heading off to college each year. You think, oh gosh, if something happens, certainly, the school is going to contact me and let me make decisions for my son or daughter off in another state. We had an incident years ago where a young woman got hit in the head with a field hockey ball, and you think, oh gosh, well certainly the parents will be able to communicate with the school, but because they had not taken the planning procedures to get a healthcare power of attorney in place, much more cumbersome process, getting the authority with the hospital to be able to make decisions on her behalf. It worked out okay, but again, a little bit of planning on the front end can make a very difficult situation smoother, at least from having the authority to communicate with a physician or even communicate with us here at Navarre Capital. People think, oh gosh, if something happens to me, my wife will be able to talk to Bill or Whit about their affairs, but really you're not able to. So we like to have
if
those.
we don't have the document, we can't legally do anything.
You got it.
And I remember what you're saying when my dad was unconscious in the hospital, and the doctor said, do you have the health care power of attorney? And we did, and
Yeah.
he gave us 2 decisions, and we made the one we thought my dad would want us to make.
Yeah.
But if we hadn't had it, what would we
Yeah,
have
you
done?
would have been probably having to get an emergency
Yeah.
hearing in front of a judge in that county, and you do by then. When you need healthcare decisions, you need them now. And one of the things that we do tell our clients in this process, Bill, is keep those documents on your phone. Particularly on the healthcare side of things. If you're appointed for Mary as her healthcare power of attorney, you want to have that on your phone so you don't have to be
Interesting.
digging it out of a lockbox somewhere. Is the bank closed on the weekend or whatnot? And so again, that's one of these stories that we've had, that we talk about here of having that available to show the doctor, that, hey, I'm the person that's speaking for my wife or for my loved one, and you don't have to go find a document somewhere else. So that's another aha moment people have of, wow, that's, hadn't thought of that. So.
Well, thank you, Whit.
Oh, it's
for
my
being with
pleasure.
us.
Fun chatting with you.
Thank you, and please, when you see this, circulate it to everybody you know, because it'll be useful advice for everybody. And we thank you for joining us. Take care.